Good morning, everybody. Welcome to Choppy Seas, navigating data breaches, employee privacy, and contractual safeguards. Um, I'm going to see just how many nautical analogies I can get through by the end of the webinar. I was speaking to my wife as I was preparing for this, and she said, "Don't you take anything seriously?" And I said, "Yeah, don't want to go overboard." That's the level that we're at. Thank you for laughing, Rob. I don't know if anyone else is going to, but there are quite a few more of them, and they don't get any better than that. So my name is Toby Pockran. I'm your captain today, and also on board is Rob Smedley. Rob is a director in our employment law team in Leeds. So both myself and Rob, we are employment lawyers by trade. We also regularly assist clients in respect of data privacy matters, data protection compliance programs, and employee protections around monitoring and restrictive covenants as well. Things with data breaches and employee privacy rights, they really link really closely to employment law as well. And oftentimes within these businesses, you're going to be seeing a link very much between what employees do, how they're monitored, the breaches that arise. That's normally one of the main catch points that we have for people when they're going through issues with data breaches. So next slide, please. Absolutely seamless. Love it. So the topics to be discussed today, we're going to be looking at a little bit more at data breaches in employment and the legal risks and responses that come along with that. We're looking at monitoring employees, so balancing privacy and security rights as well. And then we're going to finish off looking at documents and protections, so restrictive covenants in contracts. Now, it's going to be smooth sailing from here on out. If you've got any questions as we go through, there's a Q&A function on the chat. Please stick it in the Q&A and we'll come back to any questions that you raise at the end if you've got some time. We're looking to go for about 11:45, 11:50, something like that. So we've got a bit of time for questions at the end and you've got a bit of time to move on to your next meeting too. Also very welcome are any puns about seas or sailing, pop those in the Q&A as well and we'll definitely be reading those out at the end too. So next slide, please. We're gonna start off by looking at data breaches in employment and the legal risks and responses. So next slide, please, as well. Now, a data breach, I'm not going to go through this in any real detail, but it really is. It's a security incident in which sensitive, confidential, or protected information is accessed, disclosed, or stolen by an unauthorized individual or by way of a system. So getting locked out of a system, that can also be a data breach. If you simply can't access that data as a controller, you're in breach of your obligations to keep that data safe, right? So data breaches themselves, the classic ones you're going to be looking at are things like unauthorized access. So someone gains access to data that they shouldn't have access to. Maybe that's a computer hacker, so it's something a bit more sophisticated, something like what's happened to Marks and Spencers or the Co-op, or even just an employee who accesses a certain type of the system or files that they shouldn't therefore be accessing. Now that's a breach in itself. So what we're always looking at with these types of breaches is giving it that purportive explanation. So trying to work out what the definition of these things are. If it feels like a breach and it looks like a breach, then it probably is a breach. Now, within your businesses, there should be a data breach record that everyone has. Every business should look at this and say, well, look, we're considering what data breaches we've had over the course of the period of time when we've been operating, at the time that we've been controlling this data. Now, the ICO can ask you for a copy of your data breach records. That's the Information Commissioner's Office. They're the regulator who control data within the UK, certainly. They might ask you for that data breach record. Now, if that data breach record is squeaky clean, we've had no issues whatsoever, that's pretty unlikely. It's unlikely that any business that trades on any type of data or has any employees hasn't at least had one or two breaches or even near misses during that time. I would encourage you to also record near misses if you can do. So not having anything written down, very similar to how the health and safety executive deal with accident records that are completely clean. It's not indicative of a workplace that's entirely safe. What it's indicative of is underreporting. So please encourage everyone, if they have a data breach, they think a data breach might have happened, there's unauthorized access to the system, they sent the email incorrectly, they're not sure what they did on this file, they've locked themselves out, record that on the data breach register and have a lessons learned document that says, this is what happened, this is what we did. Because one of the common ones, the real, Rob, I'm sure you see this too, the real issue we come across is accidental disclosure. People, bless them, just trying to do their best, and they'll send an email to the wrong person with the wrong attachment on, and it can cause real significant issues. And the biggest example that I had with that, so again, I think everyone on this call has probably done it. You typed in an address, it's got the incorrect email address at the top of it, you've not noticed, and you click send. Now, most of the time, not really an issue. There's unlikely to be anything that's going to be causing real particular concern, because if there was, you might have taken a little bit more care. But one recently where it was a medical report about an employee. It was a member of HR team who was going to send it on to a manager. Within that medical report, there was some real significant, serious issues about this person. It had like significant sort of childhood trauma, and that had been dealt out within this report. But rather than sending it to the manager, she sent it to everyone. She sent it to a whole employee list. And so this attachment to it, which was also unencrypted, so no password protection control over it, had his name all over it, had an email that said, please see the attached. Everyone opened it and saw it. And the catastrophic impact that came from just a simple mistake on accidental disclosure was very wide reaching. The loss of trust that that employee had with everyone. And it couldn't have happened at a worse time, I think, because we're going through a dispute as well with that person. But accidental disclosure, it's one of the most common ones that we see. Almost certainly a breach. You need to be looking at those systems to see whether or not there's anything you can do about it. I think a lot of time people go, they just type the wrong name into it. It's like, yeah, that's true, but what are we going to do about it next time? And there are systems you can use that can give a bit of pause. Outlook's got an add-on that lets you say, are you sending this to the right person? Just check that email address and make sure that it's right. But if that person does send it, always encourage open reporting. Sometimes if it's getting to be 5 or 6 or 7 breaches and it's all the time, it's the same person, maybe you want to put in place training, maybe you want to take disciplinary action against that person. But the first port of call should always be help and support. What happened? How are we not going to help that happen again? What do you think we can do in the future to do that differently? I bet that HR person's never going to send an email again without checking that name on it. But yeah, the impact of that for the business was pretty wide reaching. Other characteristics of data breaches, classic one, loss of data. The classic, leaving it on a train. I had my laptop open, I left it on a train, loaded data all over it. Hopefully I've got a password on it that isn't password 123. But within that, you can also get theft of data as well. Someone takes their phone and a night out with them. If that employee has data on their personal device that they use for work and they lose their phone, that's a data breach. If their phone gets stolen, that's a data breach that the employer can be responsible for. So keeping everyone up to date and saying, look, these are the ways I think we might lose data. And the common one you always thinking is these malicious attacks. So like, cyber attacks, phishing, ransomware, malware, compromised data security, really sophisticated stuff. If you're a large employer, you're potentially much more liable for that. But smaller employers generally tend to lose data just by accident, accident disclosure, loss, or theft that come along with it. Malicious attacks can be conducted by computer pirates. Why are they called pirates? Because they are. Brilliant. That joke courtesy of my 6-year-old son. It is also nice to see your face, Rob, because you don't know if people find them funny. I'm glad you do. There you go. Look, if you get a data breach, you've got to report it potentially to the ICO, potentially to the individuals. It depends on harm. You've got to assess that harm as well. So, something like someone's name, their email address within the business, probably something that's quite low in terms of harm. Things like national insurance numbers, their addresses, passports, financial information, you're getting in towards much more serious harm. Then you really got to be thinking about how you make those reports, whether to the ICO or to the individual connected as well. Gold standard, be transparent. Say what's happened, say what you're doing about it. Don't say, we take data protection seriously, because you see that and you see on that on the back of a breach and you go, I'm not really sure you do. What you should say is, this is what happened. This is what we've done about it. Here's the remedial steps that we've taken. Here's how we can help you to get through this. And here's what you should be looking out for as well. It's not a good situation to be in, but at very least you can get some positive kind of communications that are coming out from it as well. Now, the legal consequences that come from data breaches, the headline that everyone had when the GDPR was first introduced was regulatory fines, actually having some teeth to the regulatory framework. So big ones, 17.5 million or 4% of your global turnover, big potential chunky fines. The regulators across Europe have started issuing smaller fines, 20, 30 grand, still chunky sums of cash, but smaller fines than a couple of million. Obviously, getting the really big ones that are being issued against Meta and Google, generally by the EU. But one of the bigger issues that we're seeing, and this is a real turning of the tide, a real turning of the tide, is after the case of Lloyd and Google. So what Lloyd and Google said is that you don't have to prove a loss to be able to bring a standalone data breach claim. So it used to be, this is back a number of years ago now, that you'd have to show that if someone engaged in a data breach, that it caused you a physical loss. So your identity was stolen, you lost some money, or your ID was stolen and someone accessed your bank account, and yeah, they took out some sort of fraudulent activity on that car. And that's a loss that you suffered. That's the amount that you could then sue for in damages. So to compensate you for the loss that you've suffered. Lloyd and Google said that you don't need to do that. You don't need to prove loss to be able to bring a claim. All you have to show is that your data has been misused. And if your data has been misused, you've got a claim, right? So what we're seeing is it's a change in the market, really. So you've got personal injury solicitors who that area of law has been subject to fixed costs. So personal injury solicitors are exiting that market, and we're seeing them move over into data privacy claims. Now, in data privacy claims, what we're seeing is an issue that arises. They send a standard letter before action to an employer that says, you breached this person's data in this way. Maybe you didn't respond to a subject access request quickly enough. Maybe there's been an unauthorized breach that involved that person. And they make an offer. And the offer's 3 grand, 5 grand, pretty low, but enough to make it a bit more painful. Enough, it's like painful, but not too painful. So, enough to make it something that you go, that's, you don't really want to be paying that out. But then looking at legal fees and the cost of defending and the amount of time it's going to take, it's probably sufficient enough to be able to sell it. And it's this churnover. So bigger breaches, bigger claims, always worth defending, making sure that you've got those positions in place. But the smaller claims that we're starting to see through the mix, they're becoming more challenging to defend in that sort of landscape. But the best way that you can prevent that is with proper data protection compliance programs. So data privacy notices, training that goes along with it, records of what you've done in order to retention, how you've assessed the impact of data, and Rob's going to come on to this a little bit as well. But those aspects put you in the best position, because you get that claim through and you go, haha, here's our documentation. We've got gold standard. Maybe it wasn't an authorized disclosure, but the impact's low. We're not settling with you. And it just lets you have that robust challenge back with it. And that's the real benefit that comes from having that documentation in place. So we can just click over into the next slide, please. So we're going to look a little bit more about employer responsibilities and potential liability as well. So the primary liability for under the UK GDPR and the Data Protection Act is for the controller. So the data controller has liability for the data that they hold. They control that data. They're using it for our purpose. It's got to be a lawful purpose. But they are the ones who are primarily liable for any particular acts. But how this bleeds into employment law is because businesses haven't got the ability to do things themselves. They have to act by their officers, by their workers, by their employees, by their agents, by their representatives, right? So here you have this common law principle that says that an employer can be held liable for the wrongful acts committed by employees in the course of their employment. You see it in discrimination complaints, this person did this. That's going to be the liability of the employer. The employer's got deeper pockets as well. So you can sue the individual too, but genuinely you're going to be looking for the employer. It's the same in these sorts of scenarios. But the big case on it was Morrison's supermarkets. Now, it's such an interesting case, and it really went through sort of the pits and falls that happened to them. So, a chap called Andrew Skelton, right? Andrew Skelton, by all accounts, bit of a rotter, okay? So he's an auditor in Morrison's audit team. And what happened was he'd been through a disciplinary process in like 2013, and he held a grudge because of it. And what's happened, part of his role was that he had to give information to the auditors of Morrison. So he had all this data about employees. He passed that information over to the auditors, but sneaky Mr. Skelton, he took a copy of it, right? Took a copy of that data, held it himself. What he then did was he had a grudge against a chap called Andrew Keaton. He then posted the information for hundreds of thousands, over 100,000 employees about Morrison's, all their financial data, pensions data, etc. He posted it onto an online sharing website, but did it via an email address that he created for Andrew Keaton. So it looked as if Andrew Keaton had done it. Then what he did, which is, nefarious to the extreme, was he then reported the data breach to a load of newspapers. So he got like 3 newspapers. He got the CDs of all the data and sent it to them, purporting to be a concerned member of the public, and in essence, blaming Andrew Keaton. So what happened to Mr. Skelton? He's now, well, he was, at His Majesty's pleasure, he got 8 years in a nick for all the criminal acts that he'd engaged in. But the outcome for that for Morrison's was a bit more interesting, because what happened there is that all the claimants, all the employees had their data breached, they all sued Morrison's for that data breach. So the question that was being raised here was, look, are Morrison's liable on a primary basis for that loss? So, you had that data. You should have kept that data safe. When that data was disclosed, are Morrison's primarily liable for that because they are the controller? And are they liable with vicarious liability? Are they liable for the actions of their employee during the course of his employment? And that was the real test here. And what was really interesting about it was because Mr. Skelton was off on a frolic of his own. So he had this personal vendetta, and he was like, right, I'm going to get Keaton, and I don't like Morris, so take me through this process. I don't like that. I'm gonna be out to get them. And because it's often a frolic of his own, it's whether or not that had a reasonable connection to the way in which his employment operated. So he had access to the data because of his employment. Like there's no way around that. It's not his data. He got it from Morrison's. But the acts of an employee are only the liability and responsibility of the employer if they're done during the course of that employer's employment. Now, when the claimants originally brought the cases, it went through some real sort of ups and downs with it. Whereas the High Court and the Court of Appeal both disagreed, saying respectively that it was Morrison's fault and it wasn't Morrison's fault. And then what happened was the Supreme Court got hold of it, and they found that in this specific instance, it wasn't Morrison's fault. Right? There wasn't a sufficient degree of connection between what Skelton was doing and his employment with Morrison's. And it's this real fine balance between, and because Skelton was often a frolic of his own, he was determined to be the data controller, even though he'd lawfully accessed the data. So the data lawfully from Morrison's, the copy of it became his. He became the controller in that instance. And what the UK GDPR said was the DPA at the time, but what it says now was that the controller is liable. So he was liable for it. So so the primary liability test aspect of it fell away because he was doing this nefarious deeds. But then Morrison's, were they then vicariously liable? Now, if Skelton had, rather than sending that data to the auditors, had accidentally sent it somewhere else or accidentally posted it online, good faith, good feeling, etc., then Morrison's would have been liable for that act. But because he had a personal vendetta against them, because he was acting on his own account, it was found that that was sufficient enough to break the close connection test between what he was doing and what Morrison's were primarily liable for. So it's interesting, this outcome for it, because we all breathed a bit of a sigh of relief, because the finding that Morrison's were at fault for a malicious actor undertaking action that was designed to harm them as a controller was very worrying, because it was like, well, what are we supposed to do? We can only put so many data protection controls in place, and this guy was a criminal. But the outcome to it was that Morrison's have managed to avoid that liability. So we'll breathe a collective sort of sigh. But employers, it's not a complete free pass, because you can still be held liable for negligent or accidental breaches too. And what this brings me very nicely onto is the next slide here. So just next slide, please. And it's effective response strategies that mitigate risk, right? The fines that you're going to get as a controller are going to be big if you've not done anything, right? So if you don't have any technical controls in place, if you have no documentation in place, you've not done a record, you've not had a data map that says where data is flowing from and to, you've not got a retention record in place, you've got nothing in there, your fine is going to be pretty chunky, right? And you won't be able to defend the case that any employee brings against you. But if you've done something, it's just not quite right, your fine's going to be a bit lower. If you've done all you can, you've effectively mitigated those risks, you're going to get either a slap on the wrist or an enforcement notice, unless the data breach is absolutely massive. So looking at effective strategies, I'm going to run through sort of the key ones that we always suggest in these scenarios. So the first one, kind of, I guess it goes without saying, but I'm going to say it anyway, is data security controls. So making sure that any individual is accessing personal data appropriately and securely. If you're using passwords, we use complex password control as well. I mean, it's fallen out of favor a bit in terms of changing passwords. People forget them and they write them down, which is inherently unsafe. We're using two-factor authentication, biometric controls, face recognition, thumb recognition, that type of thing. That's a really good way to do it. And having stagings to different ways that data is controlled, so siloing data so people can't control it. While the co-op did pretty well with their data breach recently, is they just pulled the plug when they had a breach. So hackers managed to get in and access certain front-end information. When they noticed that happening, they pulled themselves offline, and they were then able to ensure that the separate aspect of it, so the more sensitive data that they held, wasn't then accessed at that point. So that's, it's a good one. pulling the plug itself is a pretty extreme example, but it meant that they had that two stages that were in there. They'd done what they can in order to protect the more serious data that was arising. Now, audit, love an audit because you don't know what risks you've got until you've assessed them. So an audit literally is just that. It's literally someone, either in your business or externally, who comes in and audits the documentation that you've got, and then audits compliance with that documentation. Because the document's lovely and it says we do all these things and we make all these protections and we ensure all our staff are trained. And then when you say, well, have these things all been done? People go, no. Now, we did the documentation back in 2018 when we had to, but we've not done anything else further. That in itself is not having a safe compliance program. But having an audit that puts in place to it, it's brilliant. You get key stakeholders involved in it. You say what data's where, what do you do with it? Does that fit into the reality of our documentation? And if it doesn't, what can we do about that? What other steps can we take? Or it's a cracking, you can do them fairly regularly if you choose to, but really it's assessing that risk and doing something about it. You don't know what you don't know. You don't know what you don't know until you audit. So response planning as well, always a good one. So, I mean, the classic example of this was TalkTalk. So TalkTalk had a massive data breach, right? They got notified about the data breach by a data privacy security expert who found the breach and contacted them about it. And they, in their wisdom, threatened him personally with legal action if he told the press about it. And he said, I'm not threatening you. And what I'm saying is, I found all this data for your customers online. You need to do something about it, or I'll tell the press. And they said, you're going to tell the press, here's an NDA, all this sort of stuff. They tried their best to kind of shut it down rather than taking a step in order to go through that data breach. And what happened was their data breach response plan escalated the matter to their data privacy manager, or data protection officer rather. But he was on holiday. So he was in like Mauritius, like sunning himself, and there wasn't a next step. So they weren't like, well, we've escalated it in line with the process. He's got his out of office on, so not to worry. When he comes back to work, we'll sort it out. Baffling. So I always say, what's your next step? What's your next step? What's your next step? What happens if that person is out? What happens if that person is incapacitated? What team's going to look at this? But also, it's comforting to have a security plan in place where you go, right, we've got a breach. We're going to organize our task force, our team. What's going to happen? It's going to include these people, IT, the head of department that the breach has occurred in, MD, even, one of those. It builds that team already. But if there's one or two people who aren't involved in that for holiday or sickness or whatever other reason, you've got to fall back on it. What's the next step? What's the next step? That response plan is a really good way of doing it. And again, if you can put that in place and then test its efficiency before it happens, always a good one. And again, example with a co-op. What do you do at that point? Our data breach response planning is once we've notified this happened, we're just going to take ourselves offline. And that can be the final outcome. And it can also be what's going to happen to our data. Is it backed up at any point? So we might lose this, but we don't lose our encrypted other data elsewhere. And that for ransomware attacks, where they'll take your data, encrypt it, and then threaten to delete it, having a backed up copy of it, even though it's not, the best outcome, because it might be a slightly delay and you might lose a bit of time, at least you've not lost everything. Then developing appropriate data protection policies and procedures, and then actually adhering to them. That's always a good one. So we've got that in place. They're very chunky. Data protection policies, Rob and I, we draft them, and they can be really long, depending on the type of data that company is using. You're drafting it to yourself, really hope that people react to this. And I think it's taking that policy then and making it a live thing for your employees. And that training is by far the easiest and most appropriate way of dealing with that. Regular training is a requirement under the regulations. We always say you don't have to go too heavy on it, but every year, 2 years, like that, drop-in testing training as well, having little data protection days where people talk about potential incidents that they go from, using the people who are using the data to give that information. That's always a key. So I will pass over now to I was going to call you the bosun then. I don't think I don't know if that's the correct term for you.
Go for it, Toby. Thank you. Smooth sailing so far. I think that's the limit of my nautical references for now. But thank you, Toby, and good morning, everybody. So I'm going to now look at the issue of employee monitoring. And if I can have the next slide, please, Jordan. And before we kind of touch on, what is the law, and we're not going to get into too much detail in terms of the technical areas of law in this area, but I think it's important just to take a moment to consider and think about what we mean by employee monitoring. And if we look into our organization and even take a step back and look at our kind of own day-to-day working lives, it's quite interesting really in terms of the level of monitoring which goes on, the level of potential monitoring which could happen in the future for us and our organizations, just to kind of get a feel for how important this area is. So, you know, we think about some of the traditional examples where monitoring may have started in the past in terms of telephone use by employees, email content and traffic by staff, internet use, you know, classically tracking the use of internet within the workplace or on work devices. And then we've kind of really moved into much more detailed analysis of data activity or device activity, whether it's through work phones, whether it's through laptops and PCs. So not only, you know, when someone's switching on and what they're looking at, but what are they doing with that information and data? And most people will be familiar in terms of how that's really developed in recent times around the level of kind of activity on mouses, mouse click activity or keystroke activity on keyboards, or the ability of employers and organizations to look at what employees are seeing on their screens to kind of join that viewing. So it's really kind of developed and widespread in terms of device activity and tracking that. Physical tracking of people and staff. So whether that's through, again, IT devices or through vehicles, you know, that happens a lot within organizations. CCTV and video surveillance, again, widespread, really kind of sensitive area of employee monitoring. And it can be in the context of ongoing kind of day-to-day systematic CCT and video surveillance, or more kind of bespoke ad hoc, you know, something has happened or is happening within the workplace and we want to introduce this as a one-off kind of monitoring activity. And then there's just general access to sites and buildings. You know, most of us will have been monitored today as we entered our work site, our work location, and we'd be monitored again as we move around or leave our building or site. And that, again, that kind of access monitoring goes into this, and Toby's touched on it already, or the kind of the use of biometric data, biometric information monitoring, the use of fingerprints, facial recognition. So by kind of taking that step back and looking at ourselves, our own working days and our organizations, we can immediately get a feel for kind of how widespread this is. And also for an organization, you know, it's not just about managing risk, but are there actually opportunities here? Are there areas of monitoring that we should actually be looking at in terms, you know, to help us in terms of business protection for ourselves and our organizations? So that's the first point. You know, what monitoring is happening within our organizations, what monitoring is out there that we could actually start to investigate and explore. But alongside that is this absolutely fundamental question about why do we as organizations look to monitor employees? And this kind of comes out in terms of the practical takeaways that we'll speak about shortly. But it's that real focus on the purpose, because if there's so much monitoring activity going on, sometimes it is easy to lose track of, you know, the reason why, the purpose behind this. So many of you will be very familiar with the reason why, you know, tracking performance and productivity of staff, the quality of service to our customers and other third parties, trying to prevent and control damage to reputation or loss of confidential information and trade secrets. And then there's the prevention of theft or loss of physical assets, physical property in the workplace, prevention of loss of business generally, so protecting the business, but being specific about the why. There is the whole IT side of things. Toby's kind of already kind of gone into some of these areas, but trying to prevent or mitigate, you know, hacking into our systems, viruses entering our systems, kind of controlling through monitoring of activities in that context. There's the overall, you know, why we do it to try and control or mitigate legal liabilities arising through the behavior of our staff. So here we're thinking about things that in terms of harassment towards colleagues and, again, third parties, discriminatory behaviour by staff, defamatory behaviour by staff through activities, potential negligence by staff. So using monitoring systems and activities to try and have some control over those types of liabilities as well. Obviously, safety as well, depending on the nature of the business, but often monitoring is there as a positive to try and protect employees and third parties and provide a safe environment. And for some organizations, the reason why goes to regulatory reasons. So financial services may have regulatory requirements which compel them to have certain monitoring systems and safeguards in place. But really, again, really important, what type of monitoring takes place and why do we do it? What is the purpose? And being very aware of that and reviewing that as we move forwards. So the actual the technical legal landscape, I mean, it's not an easy one. You know, there's no single piece of law or legislation which looks after employee monitoring. And I guess for people like myself and Toby, you know, this is why we find it interesting. It transcends different kind of areas of law, and some of them are really kind of quite techy. We're not going to go into those today, I promise. But if we think about going right back to kind of the European Convention on Human Rights, and Article 8 of that convention essentially is simply the right to privacy, the right to a private life, and the right that has now emanated into the UK through our own Human Rights Act. So it sits there as a kind of backdrop to so much of what individuals have as their own personal protections, and how that then moves into the workplace environment, and how courts and employment tribunals will look to try and make decisions and take these types of kind of fundamental human rights into contemplation when talking about decisions and how other legislation should play out. So the right to privacy and how that plays out in the workplace. Monitoring. So Toby's already spoken about GDPR and the UK Data Protection Act. You know, monitoring staff activity is processing personal data, as Toby explained. So we need to think about, as an organization, you know, complying with the principles of the Data Protection Act. We need to consider, certainly for more sensitive and bold employee monitoring, you know, what is going to be our lawful basis for this monitoring if we are challenged, and are we going through the other principles to ensure that if challenged we are compliant with the Data Protection Act. The Information Commissioner's Office, the ICO, is the regulator in terms of pure data privacy considerations, and they do issue helpful guidance. So we do currently have a useful guidance document from the ICO, which is really helpful. And personally, I think it's helpful because it's one of those guidance documents that goes into real life examples, so you can kind of relate to it for different types of organization situations. So data privacy law is a real obvious consideration. We then have more kind of techie areas of legislation. So where we're talking about the interception of electronic communications. So the fact that, you know, intercepting emails and other communications between your staff will trigger rights and responsibilities under the Investigatory Powers Act, and supporting regulations there is something to think about as well. And then the kind of the main world that Toby and I operate in is employment legislation itself. So if we are talking about, you know, discriminatory behaviours or discrimination protections, we've got the Equality Act considerations that we are treating employees in such a way that we are minimizing or controlling the risk or reacting to incidents of discrimination that are arising through the way that we monitor our staff. Unfair dismissal, if we're looking to take action against individuals, for example, in relation to misconduct situations, and we're looking to use evidence that's been obtained through monitoring, you know, are we going to fall foul of employment tribunals in terms of, you know, the reasonableness of process? And again, those employment tribunals will look to other areas of law in terms of their decision making on fair and reasonable process. And then there's constructive dismissal scenarios. So if we are monitoring employees and we're not telling employees, or we're doing it in a heavy-handed manner, that an individual could say, well, that amounts to a breach of an implied term in the employment relationship, and resign and claim constructive dismissal as a result. So monitoring staff, it transcends lots of different legal areas. And I think if we can try to approach this rather than trying to understand all the technical areas. I mean, we've even got AI as well, so we should touch on that. As AI develops, there's going to be some very technical law and guidance in that world as well. But rather than try to understand all the technical areas, I think there's a kind of an element of principles or questions that we should be asking ourselves. So Jordan, if we can move on to the next slide, please. And again, we've touched on this already in the session, but the concept of balancing the rights, the legal rights of the individuals with the need to protect the business. And the way I kind of consider this is around this concept of principles or questions, because these come out, all those different areas of law that I refer to, these kind of principles or questions kind of come out as a common theme in so many of these in terms of compliance. So we've already spoken about the reason why, why as an organization are you monitoring? What is the specific purpose or objective of this monitoring activity? Is it a legal requirement that you have to do it? Or is it that it's something as a business that you want to do and it provides a legitimate business interest for you? What is the level of importance attached to that monitoring in the context of your business? If we're talking about the safety of employees, then obviously it's going to be up there in terms of the reason why we're doing it, compared to just being a nosy employer and just wanting to kind of see what's happening with employees just in case. So that kind of the reason why, top of the list. And then proportionality, again, Toby touched on it as well, but very important in the context of employee monitoring. Rather than a knee-jerk reaction to go out and engage with the type of monitoring, have you considered whether it's proportionate to achieve that aim, that purpose? So are there other ways that you could carry out this monitoring that are not so intrusive on that employee's privacy? We can get to the same end result by doing things in a different way. Are we considering, are we going to try and use a sledgehammer to crack a nut? We need to, again, take a step back and look at the different alternatives. And proportionality is something that across all those areas, again, of law that's really important. Transparency is another key consideration. So have you as an organization made employees aware that monitoring is taking place, is going to take place? Has it been done well in advance so that employees have opportunity to ask questions? Have you given sufficient detail around that monitoring, the why, the how, etc.? Did you even consult? Obviously any type of consultation, especially for more serious types of monitoring, will find favour with the courts. And that's not to say you need to reach agreement with staff that it's going to happen or happen in a certain way, but certainly letting them know and letting them have their say will be a big positive. Also consideration of the type of data and information we're talking about. So again, it kind of goes without saying, the more you start to monitor and either intentionally or inadvertently gather things like special category data, information about people's health and other areas of special category data, it raises the stakes on that monitoring activity and your ability to justify it to staff, to regulators, to the courts if challenged. The location and control of the data is also a key consideration. So especially in the modern world where we've got hybrid working, the ability of an employer and organization to see what employees are doing in their home environment, again, raises the stakes in comparison to what happens in monitoring in the office. And the device, we have a world where people have work devices and personal devices, and on those devices they kind of operate across borders. They're using a personal device for work activity and vice versa. And again, I've mentioned systematic processing. Are we engaging in systematic processing? Are we using AI? Are we using software applications which start to move into decision making on behalf of the organization? So this is again a key principle to keep in mind. The expectations of privacy on the individual and the staff member is also really important. Consequences for them in terms of that monitoring, but for their individual rights, again, is something we need to think about. Be in their shoes. How will it impact them? And finally, third-party involvement. If we are using or going to engage in monitoring, which is going to use a third party, we are potentially going to be passing personal data and information outside of our organization and getting that third party to assist. So what control do we have over that third party and that kind of monitoring that they are carrying out on our behalf? Next slide, please, Jordan. So if we all of those things in mind, you know, the kind of principles to keep in mind to try and ensure compliance with that, and also work towards good employee relations, what can we think about and take away, or what should we be thinking about in terms of our planning and strategy? Well, accountability. So employee monitoring sometimes may be picked up in a discrete part of the business, and other parts of the business or senior teams, in-house counsel, HR are not aware. So who has overall accountability? What are the different roles and responsibilities across the organization? Is this a HR thing? Is this in-house legal? Is this a data protection officer's responsibility? Other? So overall accountability. Audit, Toby's mentioned audit in the context of data breaches. Very much the same in relation to employee monitoring, and could they be combined as part of an overall annual audit or ongoing audit process? You know, what do we do in the context of monitoring within our organization? What do we intend to do? How does this link into strategy? And that could be overall business strategy, people strategy, data strategy, etc. So, and the reason I mentioned strategy is because as soon as we start to kind of see what we do in terms of monitoring, or more importantly, what we plan to do, that we consider this principle of data privacy impact assessments. So DPIA, to those data privacy lawyers out there, is such an important tool and consideration for an organization in the context of workplace and staff monitoring. And this is essentially risk assessment. And it's that ability to, you know, again, stop before launching into a monitoring activity and go through those types of questions and principles I refer to before making that decision. Have we got the balance right? And again, the reason I flag this is because in your organization, it doesn't have to be a really technical, complex, time-consuming exercise. It can be simply thinking about, you know, we're going to introduce CCTV. We believe theft has been taking place in this particular area of the business. Have we tried other means to try and get the evidence of this? Yes, we have. This is our last resort, but this is theft, criminal activity. For a short time only, we are going to go into CCTV. And we've got that rationale, that assessment, all in place before we launch into the activity. Just briefly on consent. Consent seems like an easy solution, but you know, it can actually be a difficult one to enforce from an employee staff perspective, because there's a question mark as to whether it's freely given in the employment context. So kind of word of caution around using or trying to rely upon consent to justify lawful monitoring. Notice and transparency, again, that concept we've spoken about. Privacy notices, absolutely key. Again, Toby's touched on them. And again, you know, just this last week, I've asked somebody about privacy notice within their organization, and they sent me a data protection policy. It's not the same thing. They have very different purposes, and consequences, again, of getting that wrong can be significant. So the privacy notice that goes out to your staff, that tells them about monitoring, tells them about the types of monitoring that you're doing, the reason why, you know, what are there in terms of the safeguards, limitations on time, etc., their right of access to see what's produced from monitoring. So privacy notice, again, alongside data privacy impact assessments, really, really key in this area. And policy reviews. So again, like Toby, in the kind of data breach context, from a staff monitoring perspective, have we got policies that are fit for purpose? You know, a monitoring policy, an electronic communications policy, whatever it's called, it needs to cover and guide staff about the do's and don'ts in terms of use of IT, of devices, and so on and so forth, so that employees can have no excuse when they step beyond the line in terms of their own activities and use of company time and equipment. So those are kind of some of the key points really from a kind of best practice and compliance perspective. Hopefully they will assist. And I think, Toby, we're now on to our final section.
Thank you very much, Rob. An absolute tidal wave of information there. So thank you. Um, yeah, I'm just going to look at just in brief detail on documents of protection, so restrictive covenants and contracts. And we think that this matches up quite well with data protection, because it really is how you can control an employee once they've left your employment or during your employment as well. So yeah, my first part of this is just going to be looking a little bit more about what restrictive covenants are. So a restrictive covenant in a contract, it's designed to protect or safeguard either a company's competitive advantage, the way in which they work, and also their sensitive information as well. There are some aspects that are very worthy of protection. So, protection about client lists, protection about competition, protection about workplace security and how employees are engaged as well. And then the know-how, the makeup, the information that that business uses in order to do the commercial aim that it has. So all these things are worthy of protection, but the way in which restrictive covenants work is they're designed to stop someone trading freely. So the principle is they are void as a matter of public policy unless they are no more significant than is necessary. So they have to protect a legitimate business interest. If they go too far, they are unenforceable, right? And Rob's going to touch on enforceability in a lot more detail than that. But the principle here, and it is an important point to note, they're void first unless they're reasonable. It's not they're reasonable unless they're too far. It's the opposite test with it, and it's designed to allow people to trade freely. And there's a couple of different ways in which you can protect your business. The biggest one, I have to say, is non-compete. Right? Non-compete is it sounds. It stops an employee from competing with you. So an employee leaves, they can go to a competitor, they can start up their own business. A non-compete prevents that, but it is viewed through dim eyes by judges because they are very significant clauses, and it knocks somebody out of a market for a set period of time or working in their chosen industry for a set period of time. That is against public policy to allow freedom to trade. Only use non-compete if it's something that is so significant, if it's something that could really, really inherently damage your business, right? Someone going to a competitor, or they've got real key information that would help another competitor's aim. That's probably getting towards okay. Don't use it for lower level employees. It's just not going to be appropriate. But then the other types of them, non-solicitation, that covers quite a few different things. So non-solicitation is preventing an exiting employee from either soliciting a client or a customer or an employee. So the employee is often called non-poaching as well, but it's a type of solicitation. And it's in essence, it's an offer, it's a proposal. It's a, hey, I've left. Do you want to come and trade with me and my new employer? I know that I said my current employer was great, but actually this new employer is really great. Do you want to come and follow me, right? And it implies some level of direct or indirect solicitation, an act of reaching out to try to move that business across, right? Now, it's regularly found by the courts that posting a job post on LinkedIn to saying, hi, everyone, I've moved to a new role, that can't be solicitation because that's just fact and circumstance. But what they would then go on to say is, have you seen my post on LinkedIn? I have moved. That would be an act of solicitation. In the same way with employees, it'd be encouraging them or endeavoring to either offer them new work or to help them to move elsewhere. Now, that in itself is something that's worthy of protection, but only to clients or employees that are significant. So a lower level employee, unlikely to cause damage to the business, not something that we should really be protected. But you can also get this thing called non-dealing covenants as well. And that's where it stops a client from moving over to following that employee to a new employer in that respect. So rather than the employee reaching out, the client says, well, I'm not staying here with you guys. I'm going to go with them. I'm going to move over with them instead. The non-dealing would also prevent that move as well. Bit more complicated because would you have suffered a loss anyway in terms of that client moving? Probably, even if there wasn't a breach of contract. But that's what non-dealing is designed to do. And it kind of covers off all those bases. You got the non-sol, which stops you from making the contact, non-dealing, which stops them if they're coming over to you. And there are some other broader covenants as well. We've seen a lot more of. Non-interference is an interesting one. So don't be silly about our business. Don't start kind of contacting other people and trying to get them to move away from us, or a restriction on dealing with suppliers. All these things, the more you put in, the more likely they are to be challenged, the more likely they are to be criticized. So think about what's necessary and what's needed, and then draft what you think you need for reasonable business protection. And Rob, I'm going to flick it straight over to you to just look at a bit more about enforceability and how to draft those contracts.
Thanks, Toby. Yeah, next slide, please. So, yeah, I mean, again, for Toby and I, if we are asked to support on a situation, you've had an individual who's left your organization and there are rumors or indeed evidence that they are misbehaving and causing potential damage, you know, the starting point is to look at their contract, and are there restrictions in there? And if so, what does the drafting look like? And as Toby explained, you know, this is they are the starting point. It's an unlawful restraint of trade. So if the courts are going to operate by exception to support your organization in taking action against that individual, the drafting has to be really spot on. Because if the drafting of those restrictions is defective, you know, we're already on the back foot, and we will have a difficulty, if not impossible, to have any platform to take action against those individuals. So you'll see the likes of Toby and myself wanting to get hold of the restrictions to see what the drafting is like. And if you're involved in that drafting, you know, as Toby said, it's got to be really carefully drafted. In an ideal world, you know, restrictive covenants would be drafted on a bespoke basis in relation to each individual employee. But obviously sometimes, you know, commercially that's not possible, but there has to be kind of that application of thought. So again, another example, I had an organization this week that just sent me their template contract of employment, and it just included basic restrictions for every single employee. Now, the reality is that is unlikely to get off the ground if ever needed, because it's just there's been no thought or rationale around that individual's role, what they do, the ability of them to cause damage to the business or organization. So a kind of real watch out around how courts look at this and the importance of the drafting itself. When we talk about duration, you know, each restriction, it should only go so far as necessary to protect that specific business interest. And again, you know, it needs to be carefully thought out about the amount of time that is needed to protect that. Is it a customer supplier list? Is it a specific type of information or design? What is the shelf life of that interest or information that you are trying to protect? And that should be the realistic timeframes that are used with that application of thought. The same for geography, you know, so we've got to be careful that we don't overstep and have a really wide geographic scope for a restriction that is completely unrealistic. So that individual, that sales manager, you've tried to restrict them globally, well, they only operated in Yorkshire. So again, the application of thought around geography and giving you, the organization, the employee, the best chance of making those restrictions enforceable. And this overall concept of reasonableness. And if a court deems that you've tried to go too far in one of these aspects, and the restrictions are unreasonable, they will fall away, and we have some real difficulties then in trying to take action, even if it's only to threaten action, if it can be seen that they are just not reasonable in light of the evidence. And also that the reasonableness is assessed at the time the contracts are entered into. So when we bring somebody on board, that is the critical time for restrictions. And if restrictions have been in a contract for years, they're likely again to essentially gone by their sell-by date, and we may need to consider putting new restrictions in place through promotion or some other means to make sure those restrictions are up to date and reasonable in the context of current activity. Next slide, please, Jordan. So just finally on restrictions, just a point really around, yes, as you will no doubt know, and a reminder today about how important they are as a tool to protect business, to protect assets. But I also wanted to flag they kind of sit alongside, you know, clauses within contracts around confidential information. So often there's a real focus on restrictive covenants. Get to those, see are they drafted well? Do they give us a chance? But what do the contracts also say about confidential information and confidentiality? Because most of the time that is incredibly important as well. That is an asset to your business, and if the obligations and clauses on confidentiality and confidential information are not up to scratch, again, that can cause a real issue, because often it's hand in hand. It's restrictive covenants and the confidential information, and also for some businesses, intellectual property as well alongside those. So it's important we have a full and round picture of the whole contract, the whole situation, and that goes into the final point around definitions. You can have the best section of restrictive covenants in your employment contract or service agreement, but if the definitions, which sometimes are held elsewhere in the contract, are not great and not clear and are defective, then again, that can cause a real technical issue in trying to argue enforceability about those restrictions. I remember a case of looking through a set of restrictions, best ever in the world on the face of it. But when I came to a termination date, it's obviously pretty critical for a set of restrictive covenants. There wasn't a definition for a termination date in the whole contract. Whole thing just falls away. So definitions, incredibly important, relevant. We work through the rationale of those to try and increase and maximize our chances of enforceability. I don't know, Toby, if there's anything else you want to just flag on restrictions before we move to questions.
Absolutely spot on. Well, I think we've had a few questions that have come through as well, so it'd be great to
yeah. So questions.
George, can you just pop us onto the question slide, please? Just the next one over. Cracking.
So Toby, I think question from Laura: what if something is disclosed for one purpose, whether correctly or not? Can an employee use the documents in future for any purpose, or is there any way to restrict the use of data once it is disclosed? Presumably not. That ship has sailed.
The ship has sailed. That's brilliant, Laura. Yeah, what an absolute hero. Yeah, I mean, once you've got the data for one purpose, you're stuck with it. You've chosen your purpose potato. So if you've got the data lawfully for one particular purpose, that's it. That's the only purpose you can use it for. So that's the importance with privacy notices. Within that detail, you've got real significant ability to say, we've taken this for all of these things. That's absolutely fine. But if you don't include that, you've only got one thing that you can use it for. And then eventually what you have to end up doing is serving a change of purpose notice. So you can, times when you get like privacy notices from businesses and they say, we have now updated our privacy notice, normally within that, it's a change of purpose. And as long as that purpose is lawful and it's in line with the information that was originally given, you're probably okay. If you don't do notification, you can't use it for anything else lawfully.
Thank you, Toby. And I think the next couple or the other couple are for myself. So from Katrina: in cases where an employer is considering CCTV in the workplace, are there any key elements in terms of policies or steps to implement that are must to action or consider beforehand from the compliance perspective? I mean, CCTV generally is seen as a really kind of intrusive form of workplace monitoring for obvious reasons. It can pick up so much. It can pick up lots of individual activity, third-party activity, etc. So it's seen as a really, serious kind of type of monitoring that we have to take seriously in terms of preparation and compliance. So we're back to the kind of risk assessment, DPIA type exercise. And there is a separate set of guidance, because it's such a serious issue. There's a separate set of guidance from the ICO in relation to CCTV monitoring. It sets out all the kind of practical steps you should follow. There are very practical issues around signage for individuals. So again, that advance warning to people that CCTV is taking place and the reason why. There are, again, strict rules and guidelines around how long that CCTV footage should be retained for before destruction. So it's right to kind of, I think, treat CCTV very separately in terms of an approach and having a kind of a risk assessment in place and following the ICO guidance. Finally, what is your opinion on covert monitoring? So I think touched on it briefly, but in my mind, I don't know, Toby, if you're different, but covert monitoring, yeah, it's a really kind of serious issue again in terms of staff monitoring. It's a kind of last resort type thing. If there is a suspicion of criminal activity, if there is some suspicion of gross misconduct activity, then it might be that you can justify covert monitoring. But again, you've got to kind of go through that risk assessment process. And if you obtain evidence, you've got to be really careful around how long you hold on to it, who has access to it, other control mechanisms. So, Toby, I don't know if you've got anything else on covert monitoring.
No, I've seen it before with an employee monitoring policy where there is a guideline about when we might use covert monitoring. I think using covert monitoring without making anyone aware of it is a recipe for a breach of contract claim. However, within an employee monitoring program saying this is what we would use it for, and it's only in these very significant instances and only by people who are authorized, then okay. Once that information exists, it can still be disclosed. But I have to say, if you're using covert monitoring, you've got to let people know about it. I think there are a couple more that are just
sorry.
well, Rob. Yeah, they're coming in thick and fast. Can we just take like two more, so we're coming straight up, close up to time.
Yeah. So, is the privacy policy part of data governance policy or a separate one?
So you have your data protection policy, which is probably your data governance policy. Your privacy policy is more likely to be a privacy notice. So that would be something that you issue out to employees, anyone else through staff, so workers, contractors, anyone else who accesses the building, and then customers as well. So yeah, so the privacy notice itself is something that you're telling a data subject about how you're using their data, and actually include everybody. And then your governance policy is what you then do with that data thereafter, and how you guide your employees about what the steps they should take.
I think we're actually just on 12. So there are a couple of extra questions. Toby and I will endeavour to get back to those individuals with responses. There's apologies with a couple we didn't quite get to, but we're conscious that we're right on 12 o'clock. So on that note, I guess it's a big thank you from Toby and myself for joining us. And yeah, hopefully see you on the next session.
Great. Thank you very much, everyone.
Thank you.
Thank you, Rob.